In this chapter, we will discuss employee safety, health, and benefits. Once completed with this module, you should be able to identify and describe the laws in place to protect employee safety, identify and describe the laws in place to protect employee health, explain the purpose of the Fair Labor Standards Act, explain the purpose of the Family Medical Leave Act, identify and describe employment benefits common in emergency services, explain the purpose of the Patient Protection and Affordable Care Act, explain the purpose of the Employee Retirement Income Security Act, explain the purpose of posthumous benefits, and identify and describe financial planning and management tools that may be available to fire and emergency service responders. The scenario that begins this chapter places you in the shoes of an EMS manager considering whether to change the working hours of your paramedics to 24-hour shifts. The fire department down the street runs 24-hour shifts, and you think it may be a good cost savings measure. Someone mentioned, however, that your paramedics would be entitled to overtime if they work more than 40 hours in a week. Is that indeed the case? If so, what is the difference between the firefighters down the street and your paramedics in this context? As you will see later, this is a Fair Labor Standards issue, and there could very well be a significant difference between those firefighters and your paramedics. We'll talk about that soon. As an introduction to the materials within this chapter, there are many laws at both the federal and state level that directly affect the safety, health, and well-being of firefighters and EMS personnel. This chapter explores many of these laws and how they protect firefighters and EMS personnel within various facets of their work activities and overall employment. We will begin by looking at workplace safety as applied to fire departments and EMS agencies. The most pronounced piece of legislation that governs workplace safety is the Occupational Safety and Health Act of 1970. This law attempts to ensure a safe and healthy working environment for employees by setting and enforcing standards while also providing training, outreach, education, and assistance. This act also created the Federal Occupational Safety and Health Administration, OSHA. Pursuant to the act, OSHA promulgated regulations related to safety and health. These regulations are more descriptive than the Act itself and define specific employer requirements for maintaining safe and healthy workplaces for employees. One very important facet of the Occupational Safety and Health Act and the regulations promulgated by OSHA under the Act are that the laws apply to private sector employees only. That means, on its own, OSHA regulations do not apply to governmental employers. With that being said, many states have taken advantage of federal funding to enforce OSHA regulations against both private and public employers. These states are referred to as OSHA-approved state plan states. These states receive up to 50% of their workplace safety and health enforcement program operating costs from the federal government. Those states not listed in Table 9-1 of the text are left to regulate public employee safety and health on their own. This does not necessarily mean that the provisions of OSHA do not apply, as many states adopt or incorporate OSHA regulations by reference in their respective public employee safety and health laws. As we have mentioned many times throughout these presentations, laws vary between the states. It is important for you to be familiar with the laws that apply to workplace safety and health in your respective state. If you are a private EMS agency, OSHA applies. If you are a public or governmental entity, then your state laws determine what employee safety and health provisions apply. Your state may follow and enforce all OSHA regulations, or it may not. Again, be sure to be familiar with the requirements in your state. Another facet of OSHA that must be considered is that some of its provisions are not unique. The requirements for hazardous materials response in 29 CFR 1910-120 are also duplicated in the Environmental Protection Agency's regulations, 40 CFR Part 311. Thus, even if you are a public employer not governed directly by OSHA, the EPA requirements still apply, which are the same requirements defined within OSHA. These particular requirements include the need to develop an emergency response plan, provide adequate training to your responders, utilize an incident command system, wear appropriate personal protective equipment, and so on. There are also different levels of response that are recognized, from the awareness level to that of operations, technician, or the on-scene incident commander. While there are numerous provisions within OSHA regulations, another one that has direct application to emergency services, EMS in particular, are the Bloodborne Pathogens regulations. If an employee has the potential for occupational exposure to blood and other infectious materials, the Bloodborne regulations apply. These requirements define important terms, such as universal precautions, potentially infectious material, and exposure incidents, while also establishing the means by which employers must address these various topics. Employers that fall under these OSHA requirements must establish and maintain a written exposure control plan designed to eliminate or minimize employee exposure to bloodborne pathogens and other potentially infectious material. Obviously, sick EMS providers cannot function effectively, and these OSHA regulations are very important for maintaining the safety, health, and well-being of the emergency services workforce. Where general workplace safety and health are concerned, employers must attempt to eliminate or reduce hazards where possible through the use of engineering controls and, if necessary, administrative controls. Engineering controls seek to change the work environment itself, which provides the best opportunity for reducing the hazards within a work environment. As it is not always possible to change the work environment to eliminate all hazards, administrative controls are also used to change or modify worker behavior. As a quick example, it is not possible to install fall arrest mechanisms on the roof of a burning house where firefighters must work. That is why we train firefighters to use roof ladders while maintaining 3 points of contact whenever possible. An engineering control is not available as we cannot change the work environment, so we utilize administrative controls to instill safe work habits and behaviors to hopefully minimize risk. In addition to utilizing these various controls to minimize risk, employers must also affirmatively inform employees about workplace hazards through the use of training, labels, alarms, and other activities. Another interesting facet about OSHA is that the law recognizes it is not possible to include regulations that incorporate all possible working environments and hazards. OSHA provides numerous regulations related to construction work, agriculture, maritime operations, and general industry, which are the ones that are commonly and generally applied to most work sites, but regulations are lacking for specialty or unique industries and professions such as firefighting and EMS work. Despite this lack of specific regulation for various professions, OSHA still recognizes that specific hazards exist within various industries and employers must take affirmative steps to abate them. The language in the law that requires this broad employer duty to create and foster a safe working environment is called the General Duty Clause. Essentially, under the General Duty Clause, OSHA effectively adopts industry-wide standards, if they exist, as the basis for employer health and safety activities and requirements. The General Duty Clause is important for fire and EMS as it provides a mechanism for National Fire Protection Association standards to be used as the basis of safety and health activities. On their own, NFPA standards are not laws. They are industry-wide consensus standards. Unless a legislative body adopts an NFPA standard into law, it is just that, a non-enforceable standard. With that being said, NFPA standards can have significant legal impact even though they may not be enforceable laws within a given jurisdiction. First, if a fire department or EMS agency is ever sued, the applicable NFPA standard related to the impetus of the lawsuit can be used to establish an industry-wide recognized standard of care. As we just mentioned, NFPA provisions related to employee safety and health can also be used by OSHA under the General Duty Clause to establish employer requirements related to employee safety and health. NFPA 1500, the Standard on Fire Department Occupational Safety and Health Program, for example, is one such NFPA standard that has direct application to employee safety and health and could serve as the basis for liability under OSHA if a firefighter suffers a workplace injury that could have been prevented through the application of NFPA 1500 standards. If your state applies OSHA requirements against public employers, has a state law that adopts NFPA standards, or has its own General Duty Clause, NFPA requirements related to occupational safety and health are very important as they are essentially the law that must be followed to support a safe and healthy work environment for firefighters and potentially EMS workers. Failure to follow OSHA requirements, including standards that would apply under the General Duty Clause, can lead to significant penalties depending on the kind of violation involved. Some of the most severe penalties include a civil penalty of up to $70,000 per violation with continued fines of up to $7,000 per day for ongoing violations. Some violations can even include potential incarceration of up to 1 year in prison. We spoke about administrative agencies in a previous presentation, and OSHA is no different in that it has the ability to not only write rules, but to enforce them and hear disputes about them as well. To address disputes, there is a specific Occupational Safety and Health Review Commission that provides administrative trial and appellate review for disputes stemming from citations or penalties related to OSHA inspections of the workplace. Administrative law judges conduct hearings, receive evidence, and render decisions related to these disputes. If necessary, these administrative law judge decisions may be appealed to the Court of Appeals. The Occupational Safety and Health Act also created the National Institute for Occupational Safety and Health, NIOSH, to conduct research and make recommendations to prevent worker injury and illness. Unlike OSHA, NIOSH does not promulgate rules and it does not have any enforcement powers. NIOSH is not a part of OSHA. It is a federal agency within the Center for Disease Control and Prevention. NIOSH is important to the fire service as it investigates firefighter deaths in the United States through its Firefighter Fatality Investigation and Prevention Program to determine factors that contributed to the line of duty death and make recommendations that may prevent future firefighter deaths and injuries from similar causes. While NIOSH does not promulgate rules and has no enforcement duties, the results of its investigations are commonly incorporated into future iterations of NFPA standards, which are then applied to employers by OSHA through the application of the General Duty Clause. The CDC also has an Emergency Preparedness and Response Office designed to prevent diseases, injuries, and fatalities in anticipation of and during responses to natural and human-made disasters and novel emergent events. This office worked with other agencies to develop the Emergency Responder Health Monitoring and Surveillance System, which provides guidelines for protecting emergency responders over a full range of emergency types and settings. As this system garners greater acceptance and use, it may someday evolve into another industry standard that will be applied at a practical level through the OSHA General Duty Clause. While federal OSHA provisions may or may not apply to publicly employed firefighters and EMS providers, depending upon the state in which they work, many states have laws that recognize additional protections for emergency responders. Such laws may elevate a battery against a firefighter or an EMT to a felony, or may make it illegal for motorists to drive over a fire hose or disobey a lawful order from a firefighter or EMT. Additional laws routinely govern how drivers must react to approaching emergency vehicles and may even impose additional traffic requirements on motorists approaching a fire or EMS station while apparatus is departing or returning. While many of these provisions may not be directly related to workplace safety and health, they often have the cursory benefit of increasing safety for our emergency responders. Outside of the workplace itself, there are federal laws that govern employee health in general. The first such law that we need to recognize is the Patient Protection and Affordable Care Act of 2010, which was designed to create new consumer protections, improve healthcare quality while lowering costs, increase access to affordable care, and hold insurance companies more accountable. The PPACA is a large piece of legislation weighing in at more than 950 pages. Needless to say, the width and breadth of this legislation will not be discussed in detail within this presentation. As far as the highlights of the PPACA are concerned, however, large employers with at least 50 full-time equivalent employees must offer affordable or minimum value health insurance coverage to full-time employees. Failure to do so can result in a significant penalty. If the employer is not considered a large employer under the law, it is not required to offer health insurance benefits to full-time employees. One important thing to recognize is that the definition of a full-time worker under the PPACA is 30 hours per week, not the 40-hour per week threshold recognized in the FLSA, which we will discuss later in this presentation, which is a threshold for paying overtime. Regarding the penalties defined within the PPACA for not following its provisions, the law differentiates between large employers that do not offer any coverage at all and those that offer unaffordable or minimum value coverage. This flowchart, provided by the Library of Congress Congressional Research Service, provides a process by which to determine whether or not an employer may face a penalty under the PPACA. One last important thing to recognize as well is that through significant lobbying efforts by numerous agencies, volunteer fire departments and EMS agencies do not need to count their volunteers when determining whether or not they qualify as a large employer that must provide health care benefits to its volunteers. At the time this presentation was produced, there has been talk at the federal level under the Trump administration about significantly changing the provisions of the PPACA, although no such legislation has been passed by Congress yet. If the law is eventually replaced or otherwise modified, employer requirements under the 2010 iteration of the PPACA may change significantly. As always, fire department and EMS agency administrators must be mindful of changes to laws that may have an impact on routine, daily operations of the department or agency. While not as recent as the PPACA, the Consolidated Omnibus Budget Reconciliation Act of 1985, often referred to as COBRA, continues to impact employers and health insurance benefits they provide. Under COBRA, group health plans for private employers with 20 or more employees, or for state and local government agencies regardless of the number of employees, must provide certain former employees, retirees, spouses, former spouses, and dependent children the right to temporary continuation of health coverage at group rates if coverage is lost due to certain specific events. Simply stated, COBRA is a law that allows you to continue your health insurance with a former employer for a period of time after you stop working for that employer. It is not unusual for employers to pay a portion of health insurance premiums for active employees. There is no such requirement under COBRA, which means those who avail themselves of COBRA benefits routinely pay more for group health insurance benefits than when they were employed. Even with an increased premium, however, COBRA insurance is typically less expensive than purchasing a private health insurance plan. In 1990, Congress passed the Ryan White Comprehensive AIDS Resources Emergency Act to assist individuals living with HIV or AIDS to obtain the care they need for treating the disease. This act has been amended and reauthorized numerous times since its passing. Of particular interest to EMS providers and other emergency responders is a provision that requires emergency response employees be properly and promptly informed when they may have been exposed to a potentially life-threatening infectious disease as a result of the responder's contact with patients. If the provisions of the law apply, the medical facility treating the patient must notify the state-designated official of the listed infectious disease case within 48 hours so that the official may then notify the emergency responders who transported the patient. The list of diseases that fall within the CARE Act are defined by the CDC and include diseases like hepatitis B, measles, pertussis, and SARS. A list of diseases that the CDC includes based upon transmission means through bodily fluids, aerosol airborne, or aerosol droplet means is included within the textbook. Some states have laws that supplement the CARE Act and define their own requirements for notifying emergency workers of potential exposure to infectious diseases. While it is true that patients have certain privacy rights, the laws recognize that those rights must be balanced with the need for emergency service workers to learn whether they have been exposed to an infectious disease. Such notification also recognizes the utility of having healthy medical providers who do not risk exposing others to whatever diseases they may have been exposed to previously. We will now shift gears from health and safety to hours and wages by discussing the Fair Labor Standards Act of 1938. Amended numerous times over the years, the FLSA was designed to address perceived employer abuses related to minimum wages, hours worked, overtime, and child labor. This federal law applies to all employers, including public entities, by virtue of the ability for Congress to regulate interstate commerce. While all employers are covered by the FLSA, the law does exempt certain employee classifications from its provisions. Before one can determine whether or not certain FLSA provisions related to minimum wage and overtime apply to an individual employee, a determination must be made as to whether or not that employee is exempt from those FLSA provisions. These exemptions include executives, administrators, and professional employees. Broadly speaking, the executive exemption applies to employees whose primary duty is the management of the business's enterprise, with employee oversight that includes the ability to hire, fire, discipline, promote, or otherwise change the status of an employee. So long as the executive earns a particular minimum salary, he or she is not entitled to overtime pay when working in excess of 40 hours per week. Essentially, the higher up someone is within an organization, the more likely he or she may be considered an executive under the FLSA. If an employee's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance, this work is office-related or non-manual work directly related to the management or general business operations of the employer, and the employee is compensated at a predefined minimum salary, he or she may qualify under the FLSA Administrative Exemption. Confidential support staff could potentially fall under this type of exemption. If it applies, similar to the executive exemption, there is no requirement for the employer to pay overtime once the employee exceeds 40 hours worked per week. The last exemption is referred to as the professional exemption, where the employee's primary duty is the performance of work requiring advanced knowledge that is predominantly intellectual in character that includes the consistent exercise of discretion and judgment. This advanced knowledge must be in a field of science or learning that must be customarily acquired by a prolonged course of specialized instruction. So under that definition, could one argue that a firefighter or an EMS provider is a learned professional that falls under this professional exemption? While someone could try to argue that, the FLSA specifically states that firefighters, EMTs, ambulance personnel, rescue workers, hazardous materials workers, and similar employees are not exempt from the FLSA. Thus, the wage and overtime provisions included within the FLSA do indeed apply to firefighters and EMS providers. Given that no exemption applies to firefighters and EMS providers, what exactly are the provisions of the FLSA that apply? Generally speaking, the FLSA requires payment of overtime at 1.5 times his or her hourly rate once an employee exceeds 40 hours of work per week. While this 40 hours per week requirement may sound simple on its face, there are many routine practices in emergency service professions that can cause some confusion. Think about it for a minute. If a firefighter eats lunch at the firehouse, are those hours included within the 40-hour threshold? What about hours spent sleeping or hours traveling between stations? The answer to those questions depend on what constitutes a workday. According to the United States Department of Labor, a workday in general is the period of time from when an employee commences his or her principal activity and the time on that day or a subsequent day when he or she ceases such principal activity or activities. The FLSA also defines the term employ as including to suffer or permit to work. If an employer is requiring or permitting an employee to work, those hours are compensable. If an hourly employee continues working beyond his or her scheduled end time, those hours are compensable as well. Given this definition of what it means to work under the FLSA, it is not possible for an employee to volunteer similar work for an employer. A full-time firefighter may not also pick up volunteer hours for the same fire department without violating the FLSA. The concern of allowing something like that would be employer abuses where the employee becomes expected to volunteer hours as opposed to being rightfully paid for them. This same full-time firefighter may volunteer as a firefighter somewhere else. He or she just cannot volunteer for the employer who pays him or her. Along somewhat similar lines, the full-time firefighter may volunteer for the employer to do things not related to his or her employment, like coaching a youth baseball team on behalf of the fire department. The nexus of the evaluation is whether or not the work being performed on a volunteer basis is similar to that for which the person is routinely paid. If it is, then it is not possible to volunteer, and any hours the employee puts in for those activities are compensable. Besides volunteering, as we just mentioned previously, there are many routine practices in emergency service agencies that may raise the question as to whether or not the hours are compensable. Waiting time, on-call time, rest and meal periods, sleep time, and attending trainings are just a few of those routine occurrences. Luckily, the FLSA requirements related to these topics are well defined in most cases. As an example, rest periods of a short duration, usually 20 minutes or less, are commonly considered to be time worked. If an employee takes a bona fide meal break, that is usually 30 minutes or longer, that meal time is not considered work time so long as the employee is completely relieved from duty during that period of time. As routinely happens to emergency workers, if the expectation is that the employee discontinue the meal or break to work if necessary, like when a call comes in, then those hours are indeed compensable. Sleep time is somewhat similar in that for sleep hours to be considered to be not compensable, the firefighter or EMS provider must be guaranteed at least 5 hours of uninterrupted sleep. Again, if there is an expectation that the employee wake up and work if necessary, like when a call comes in, then those sleeping hours are compensable. The textbook provides guidance on other routine practices as well, and I encourage you to review them to increase your understanding of the FLSA, its provisions, and how they relate to fire departments and EMS agencies. As of the time this presentation was produced, the federal minimum wage was $7.25 per hour, although some states have laws that require payment of a higher minimum wage. If an employee works more than 40 hours in a week, the FLSA requires that overtime be paid at a rate of not less than 1.5 times the regular rate of pay. There are 2 major exceptions to this requirement that we need to discuss, however. The first exception is the small employer exception. Public agencies that employ fewer than 5 employees during a work week for fire protection activities are exempt from paying overtime under the FLSA. The second exemption is one that you may have already been wondering about. Many fire departments, and EMS agencies for that matter, have employees who work 24-hour shifts. Depending on how those shifts are structured, it may not be unusual for a firefighter to work 3 24-hour days in a week, thus totaling 72 hours of work per week. Does that mean the firefighter must be paid 32 hours of overtime that week? The simple answer is probably not, as the FLSA contains something called the Section 7K Firefighter's Exemption. Essentially, the FLSA recognizes that many fire departments run 24-hour shifts, and it provides a mechanism by which fire departments can calculate the number of hours a person may work in a week before paying overtime based upon a work period that varies anywhere from 7 to 28 days. The way this works is that fire departments must pay overtime to employees who work more than 212 hours in 28 days, or any prorated number of hours if the work period is defined as less than 28 days. Given 212 hours in 28 days, that averages out to 53 hours per week. If a firefighter stays at or below 53 hours per week over those 28 days, no overtime is required to be paid for the 13 hours in excess of 40 hours per week. Because some firefighting schedules may still require the occasional payment of overtime, many fire departments use work reduction or Kelly days within the 28-day period to lower those average weekly hours to 53 or less. To qualify for this exemption, the FLSA requires that the employees be involved in fire protection activities. Where this language becomes particularly interesting is in cases where a fire department employs someone who does not participate in fire protection activities. If a fire department employs paramedics who are not firefighters, for example, they cannot work 24-hour shifts without the employer having to pay overtime for weekly hours worked by those paramedics in excess of 40 hours. Additionally, private fire departments do not qualify for the Section 7K Firefighter Exemption and must pay overtime once employees exceed 40 hours per week. The same applies to private ambulance services as well. Hours in excess of 40 hours per week requires the payment of overtime. If you have any questions as to what it means to be involved in fire protection activities, the textbook does list all 6 factors used in making that determination. In lieu of paying overtime, public employers may elect to allow employees to accrue compensatory time. If comp time is permitted, it must be compiled at a rate of 1.5 hours for each hour of overtime worked. The FLSA allows firefighters to accrue up to 480 hours of comp time, although employers may set lower thresholds. Any additional overtime earned beyond those maximum hours must be paid as cash to the firefighters. An employee seeking to use his or her comp time cannot be denied the request unless the use of that comp time would unduly disrupt the agency's operations. If the employee leaves his or her job with hours remaining in his or her comp time bank, the employee must be paid out at the employee's current hourly rate or at a rate calculated based upon an average over the last 3 years of employment, whichever is higher, even if the hours were accrued when the employee was earning a lower hourly rate. Managing a compensatory time system includes both financial impacts and logistical issues for the employer, which is why some employers do not permit the accrual of comp time, or they limit the hours that can be banked well short of the 480 hours permitted by the FLSA. Another routine practice within the fire service are work trades, where Firefighter A agrees to work for Firefighter B on a given day. The FLSA allows this practice given two individuals employed in the same capacity by the same public agency. The hours worked by the substituting employee are excluded by the public agency while calculating the hours worked for the substituting employee. Thus, when Firefighter A is working for Firefighter B, those hours are attributed under the FLSA to the firefighter originally scheduled, Firefighter B, not Firefighter A. If you are involved with a volunteer agency, the FLSA does allow those volunteers to be paid expenses, reasonable benefits, a nominal fee, or a combination of those for bona fide volunteer service without losing their status as volunteers. The caveat is that any nominal fee paid cannot be a substitute for compensation, nor can the fee be tied to productivity. The Department of Labor did publish an opinion letter in 2008 that recognized any fees paid that are in excess of 20% of what would otherwise be required to hire a permanent employee are not considered nominal. As an example, say that starting salaries for firefighters in your area are around $35,000 per year. If a volunteer receives more than $7,000 in fees or benefits within a year, that person is no longer considered a volunteer by the Department of Labor and must be paid the prevailing minimum wage for hours worked, along with appropriate compensation for any overtime that may have been worked. Another FLSA provision that may impact emergency service agencies is that of child labor. In some areas of the country, it is not unusual for fire departments to have explorer posts or high school training programs for prospective firefighters who wind up being less than 18 years of age. The FLSA prohibits non-agricultural employment for those under 14 years of age. 14 and 15-year-olds may work, but the number of hours and days they can work are restricted. The FLSA does not establish a limit on hours worked for children 16 years of age or older. There is a youth minimum wage of $4.25 as of the time this presentation was created that may be paid to young workers under 20 years old so long as their work does not displace other workers. Once employed for at least 90 days, however, the wage must be increased to meet the current minimum wage. If a young worker is a full-time student or student learner, that person may be paid a reduced percentage of the adult minimum wage depending on the circumstances. If your fire department or EMS agency is involved in providing experiences to students or children under 18 years old, it is a good idea to speak with a local labor attorney to ensure compliance with the FLSA. As with many of the laws we have discussed, individual states may have their own provisions that apply to these scenarios as well. In addition to having familiarity with the wages paid and hours worked for children, a more pressing prohibition is that associated with hazardous work. Under the FLSA, children younger than 18 years of age are prohibited from participating in hazardous employment. While a list of such activities is provided by the United States Secretary of Labor, the most pertinent prohibitions have been included within the textbook, and it should not be much of a surprise that some routine tasks performed by firefighters are prohibited. This includes driving a motor vehicle or working as an outside helper on a motor vehicle, forest firefighting and fire prevention, using power-driven saws, and working on or about a roof. Beyond the FLSA, many insurance companies may be reluctant to insure an employer that employs children under the age of 18 or uses them in a particular aspect of a job. Again, individual states may have additional provisions related to the type of work a minor under the age of 18 years old can legally perform. Depending on where you are in the country, unpaid internships may be a popular way of educating future firefighters while supplementing fire department or EMS agency staffing. The FLSA does recognize the utility of unpaid internships, but also has provisions that govern those relationships to ensure the intern is not being abused, so to speak. Some of these provisions include things like ensuring the internship experience is actually for the benefit of the intern and that the intern is not there to displace regular employees. A full list of the 6 criteria are included within the textbook. Internships can be offered to individuals of any age, although many fire departments use them to support high school career exploration or local community or technical college firefighting programs. Similar to many of the civil rights laws we discussed in a previous presentation, employers subject to the FLSA must post a notice explaining employee rights under the Act in a conspicuous place at all locations. Employers are also required to keep records on wages, hours, and other related information for every covered, non-exempt worker. All payroll records must be maintained for at least 3 years. Remember, while the FLSA is a wage and hours law, it is limited in its scope to subjects such as minimum wage, overtime pay standards, and the employment of minors. The law does not address vacation pay, holiday pay, sick pay, fringe benefits, discharge notices, and other related topics of employment compensation. According to the Department of Labor, these items are matters of bargaining or agreement between an employer and its employees. Penalties for violating the FLSA can vary depending on the specific type of violation. Typically, the Department of Labor requires payment of any back wages due to a wronged employee, while also mandating changes in employment practices to prevent future similar occurrences. If the FLSA violation was willful, a criminal fine, imprisonment, or civil penalty may be levied. The Department of Labor may also seek an injunction to restrain entities from violating the FLSA, and it may also prohibit the shipment of goods that are produced in violation of FLSA provisions. Remember how we said the FLSA is derived out of the authority for the federal government to regulate interstate commerce? Prohibiting the shipment of goods produced in violation of the FLSA is a direct nod at the interstate commerce origins of the law. While the FLSA does not address employee time off, there are other laws that do. One of the most prevalent is the Family Medical Leave Act of 1993. This law was developed to balance the demands of the workplace with the needs of families, to promote the stability and economic security of families, and to promote national interest in preserving family integrity. The FMLA entitles eligible employees of covered employers to take unpaid job-protected leave for specific family and medical reasons while also maintaining group health insurance coverage. To begin, employers covered by the FMLA include private sector employers with 50 or more employees, as well as public or private elementary or secondary schools and public agencies, regardless of the number of employees they have. If an employee works for a covered employer, he or she may take up to 12 work weeks of leave in a 12-month period for specific reasons as defined within the FMLA. The law also allows up to 26 weeks of leave during a single 12-month period to care for a covered military service member with a serious illness or injury. There are some requirements as to what constitutes an eligible employee for the purposes of these provisions. The two most significant requirements delineate that the employee must have worked for the employer for at least 12 months and have at least 1,250 hours of service for the employer during the 12-month period immediately preceding the leave. FMLA leave is available for various reasons, such as the birth of a child, to care for a family member with a serious health condition, or for a qualifying exigency arising out of a family member's active military service. While family members is defined strictly as a spouse, son, daughter, or parent, the law does recognize the rights of foster or step-parents to provide care. To clarify, FMLA leave is not required to be paid. The guarantee is that the employee still has a job upon the conclusion of the leave. It is up to the employer to decide whether or not other paid leave, such as sick time or vacation time, can be utilized in lieu of unpaid time during FMLA leave. To go a step further, the employer may actually require the employee to substitute accrued paid leave in lieu of unpaid time, even if the employee would prefer not to do so. While the FMLA provides some significant job security protection for workers who need to take leave under its provisions, there are some cases in which an employee's leave may cause substantial and grievous economic injury to the employer's operations. In such cases, that employee is considered to be a key employee, and the employer may refuse to reinstate that highly paid, salaried key employee. If such is the case, the employer must notify the employee in writing of his or her key employee status and the reasons for denying job restoration. The employee must then be granted a reasonable opportunity to return to work after receiving the notification. Where the FMLA is concerned, employers often wonder just what types of inquiries can be made of the employee as private medical information is involved. Essentially, employers have the right to require a medical certification before providing FMLA leave. If the certification is inadequate, the FMLA leave may be denied. If the employer doubts the validity of the certification, it may require the employee to obtain a second medical certification or even a third if the second one differs from the initial certification. Similar to the FLSA, employers must display posters in plain view that notify workers and applicants of applicable FMLA provisions and how they can file a complaint with the Department of Labor Wage and Hours Division given an alleged breach of those rights. Covered employers must also provide this information to eligible employees via an employee handbook or other written material about leave and benefits. If an employee applies for FMLA leave or the employer learns that the employee may potentially need to take FMLA leave, the employer must provide the employee with an eligibility notice within 5 business days. If an employee receives an eligibility notice, the employer must also provide a rights and responsibilities notice that further clarifies the employee's rights along with the employee's duties under the FMLA. Once a determination is made regarding whether an event qualifies for FMLA leave, the employer must provide designation notice to the employee. Upon return from FMLA leave, the employee must be returned to the same job or one that is nearly identical to the one he or she held prior to the FMLA leave. It is unlawful for any employer to interfere with, restrain, or deny the employee's opportunity to exercise any right provided by the FMLA. An employee's FMLA history cannot be used as a negative factor in employment actions. FMLA leave also cannot be counted under no-fault attendance policies, as such leave is protected by law. Additional information related to these employer obligations is included within the textbook if you would like to delve into the topic a little further. As if the legal landscape for employers was not complicated enough, many states also have their own laws regarding family medical leave as well. Because states cannot reduce the protections provided by the federal FMLA, most state laws provide expanded rights to employees while occasionally creating additional duties for employers. In states with their own family medical leave laws, state family medical leave runs concurrently with the federal leave. Penalties for FMLA violations vary a bit from those for other laws we have discussed. In the event of a complaint, the Department of Labor can bring an action in court to compel employer compliance with the FMLA. Of greater concern to employers should be the fact that employees may file a civil lawsuit against the employer seeking lost wages, benefits, and actual monetary losses. There is no need for the employee to file a complaint with the Department of Labor before filing such a civil lawsuit. The statute of limitations for such lawsuits is 2 years, or 3 if the FMLA violation was willful. We are now going to shift from federal laws to state laws that further define numerous employment benefits, such as workers' compensation, duty disability, light duty, unemployment, and others. These laws do vary considerably from state to state, so we will only take a cursory dive into these topics here. As always, it is important for you to know the specifics of these laws as they apply in your particular state. To begin, workers' compensation and duty disability laws were developed as a compromise between the employee and the employer. Years ago, before workers' compensation, if an employee was injured at work, that employee had to sue the employer to recover for his or her injuries. This was expensive and time-consuming for the employee, and it also exposed the employer to unknown and pervasive ongoing risk. The creation of workers' compensation and duty disability systems established a no-fault system of recovery for employees injured during the course of their employment. Employers are strictly liable for costs associated with the employee's on-duty injuries, and the trade-off for that is that the employees are prohibited from suing their respective employers for those injuries. These systems allow employers to budget for insurance coverage without having to bear the risk of having to pay a single large claim that could result from a standalone lawsuit. The system typically calculates premiums based upon exposure and risk associated with the underlying work being performed, along with previous experience with claims. Under such a system, employers with an unsafe workplace that has a history of workplace injuries or those within a more hazardous profession will commonly pay more for workers' compensation insurance than those employers with less risk or history of workplace injuries. While light duty is typically not codified in laws, it does tie into workers' compensation in that there is a benefit for both the injured employee as well as the employer if an injured employee can be returned to work quickly, even if that work is more administrative in nature. Many fire service employers utilize light duty assignments to return injured employees to work quicker while recovering from injuries suffered on the job. In all the laws we have discussed thus far, there is no requirement that employees be provided light duty work. Whether light duty is made available is a decision made by the employer. In light of the other laws we have discussed in other presentations, however, it is important to recognize that if an employer does make light duty available to injured employees returning to work, it must typically make those assignments available to others as well, particularly those with a recognized temporary disability. As can be the case with various laws designed to address different problems, workers' compensation laws do not always mesh perfectly with other laws. Under the FLSA, for example, time spent by an employee seeking treatment for a work-related injury is generally non-compensable time. The FLSA relies on workers' compensation as the mechanism by which an employee is paid for those hours. The FMLA, as another example, does not consider light duty an option for workers who avail themselves of the FMLA. Either the employee is on FMLA leave or they are not. The purpose of workers' compensation is also very different than the purpose of FMLA, and the two should not be confused, as employees returning from workers' compensation time off or light duty are not guaranteed their previous positions as they are by the FMLA. Duty disability is somewhat related to workers' compensation. Before we delve deeper, however, it is important to differentiate between disability insurance and duty disability. Disability insurance is insurance someone purchases in the event of a disability that impacts his or her ability to earn a living. This is different from duty disability laws that prescribe how employees injured at work are treated if the severity of the injuries precludes them from returning to work. In states with duty disability laws, it is not uncommon for these programs to retire the individual from employment and pay the person a portion of his or her salary based upon the nature and extent of the resulting disability. Unfortunately, given the prevalence of injuries in the fire service, familiarity with the workers' compensation and duty disability laws in your state is important, and I would suggest every student research these systems as they apply in his or her respective state. Another type of law that is becoming prevalent across numerous states is a presumptive disease law for firefighters. Given higher rates of cancer, respiratory diseases, and cardiac diseases in firefighters, many states have enacted presumptive cancer, heart, or lung laws that create a presumption that, if a firefighter contracts such a disease, he or she did so as a direct and proximate result of the job. Such laws, if they exist in your state, are an attempt to remove barriers for firefighters to receive treatment for the disease under the state's workers' compensation system. Because these are state laws, however, their provisions can vary considerably. Some laws will only cover firefighters who work a certain number of hours per year over a given number of years, which often winds up excluding volunteers. Keep in mind as well that while the presumption is that the disease is occupational in nature, the presumption is oftentimes rebuttable, which means the employer can try to show that the ailment was, in fact, not work-related. Even if not covered by such a law, the sick firefighter can still attempt to show he or she contracted the disease through the workplace. Given that the burden of proof in such a case falls squarely on the firefighter and his or her family, however, seeking workers' compensation benefits without the aforementioned presumption can be an uphill battle. States also have a social welfare system in place designed to provide income to unemployed workers. Through these unemployment programs, which are funded through state and federal employee payroll taxes, qualified individuals who lose their jobs through no fault of their own may receive money for a period of time, typically up to 26 weeks. The amount the person receives is usually determined as a portion of the individual's previous average wage, up to a maximum amount as defined by the respective state. Given the recession in 2008, there was considerable debate as to whether or not these unemployment benefits are valuable. Many economists are quick to point out that in times of high unemployment and recession, these funds help ensure money is still being circulated to drive the economy. Without infusing funds into the hands of the unemployed, the economy would fall even further into recession. Additional objectives include enhancing and stabilizing employment while minimizing the economic loss suffered to the unemployed by paying them benefits during that period of unemployment. Others have argued inversely that extending unemployment benefits simply extends unemployment. Whether that is the case or not is not within the purview of discussion in this text. The laws for unemployment benefits are on the books and they are occasionally updated. One such update occurred during the 2008-era recession with the extension of unemployment benefits beyond the standard 26 weeks during periods of extremely high unemployment. Despite these updates, the laws still differentiate between someone who lost a job through no fault of his or her own and someone who voluntarily quit, was fired due to misconduct, or simply did not have sufficient earnings or work enough to qualify for benefits. Those who quit or are terminated for cause are typically not eligible for unemployment benefits. Unemployment benefits are often significantly lower than what the person was earning while employed, which means the unemployed person typically has significant motivation to find another job. Some states also have laws that imbue certain procedural protections for firefighters to protect their jobs and ensure negative employment actions are conducted fairly. These Firefighter Bill of Rights laws may include language requiring suspensions to be with pay while an investigation is being conducted, or that the firefighter's previous work performance must be a factor in any type of negative employment action. Some laws prohibit the use of polygraph tests during interviews or investigations, while others guarantee the right to an appeal with a local court within a given period of time if there is a negative employment action against a firefighter. Whether such laws cover EMS providers depends upon the specific law within the respective state, along with the employee's actual job description and function. If such a law exists in your state, it is important to be familiar with its provisions. At this point, we are going to shift back to some additional federal and state laws that impact emergency service workers and their families after the employment relationship ends after years of selfless service. The first law that has significant impact on retirement benefits is the Employment Retirement Income Security Act of 1974. This federal law sets minimum standards for retirement and health benefit plans in private industry. ERISA does not require employers to establish such plans, but those who have them must meet certain minimum standards as defined within law. To clarify, public employers and churches are not covered by ERISA. Protections for public employee retirement plans are typically defined within state laws and constitutional due process protections. Additionally, plans that are maintained solely to comply with workers' compensation, unemployment, or disability laws are not covered by ERISA. For those private employers with retirement plans, ERISA sets uniform minimum standards to ensure employee benefit plans are established and maintained in a fair and financially sound manner. Employers also have an obligation to provide promised benefits while also satisfying ERISA's requirements for managing and administering private retirement and welfare plans. As far as group health insurance plans are concerned, there are also other laws that can impact the level of benefits provided to retirees, some of which are included within the text. Essentially, ERISA is a very complicated law that does not apply to municipal fire departments or EMS agencies. As a result, the text does not delve very deeply into this topic and provides information at an awareness level only. Those interested in ERISA are encouraged to perform additional research or speak with a human resources professional or an attorney familiar with ERISA for more information. There are also laws that define posthumous benefits to the families of firefighters who die in the line of duty. These benefits can vary by state. There are also benefits defined at the federal level as well. Created in 1976, the Federal Public Safety Officers Benefit Act provides financial benefits to family members of public safety officers killed or disabled in the line of duty. The law was updated in 2003 to create a presumption that public safety officers who die from a heart attack or stroke following a non-routine, stressful, or strenuous physical public safety activity or training did so in the line of duty. The law includes law enforcement officers, firefighters, rescue squad, and ambulance crew members within the definition of a public safety officer. Whether the public safety officer was a full-time compensated firefighter or an uncompensated volunteer is not relevant. Even volunteer firefighters and EMS providers are eligible for benefits under the PSOB. In the event of a duty-related death, the PSOB provides a one-time monetary benefit to eligible survivors. As of 2015, that amount was just shy of $340,000. While that may sound like a lot of money, it is not unusual for a full-time firefighter to make anywhere from $50,000 to $100,000 or more with benefits annually, depending on the area in which he or she is employed. Over the course of a career, that $340,000 is only a fraction of the income, including benefits, that the firefighter may have earned for his or her family. The PSOB also provides a one-time benefit to eligible public safety officers who are permanently and totally disabled as a result of a catastrophic injury sustained in the line of duty. That benefit is the same as if the public safety officer had died. Therefore, the disability must be permanent and total, meaning that the public safety officer is permanently unable to perform any gainful work in any type of employment. There is an education benefit that helps pay for the costs of higher education for eligible spouses and children of public safety officers who died or were catastrophically disabled in the line of duty. As of 2015, the benefit was just over $1,000 per month for full-time students. If the student attends less than full-time, the benefit amount is reduced accordingly. In the event of a public safety officer death or catastrophic disability, the Federal Bureau of Justice Assistance has a strict process for filing a claim and receiving benefits under the PSOB. Obviously, if a family is seeking to claim this benefit, they have suffered a significant loss, and meeting the procedural requirements defined by the Bureau of Justice Assistance can be just one more thing that the family is ill-prepared to deal with. Given that, fire service and EMS employers should have resources in place to assist the families of former employees in obtaining these critical benefits. While we just discussed the information related to the federal PSOB, many states also have similar programs in place that may provide a money benefit, covered education in state colleges or universities, or other benefits. While it has been mentioned before, it bears to be repeated here. It is incumbent upon fire service and EMS professionals to be familiar with the laws that apply within their particular state. While we just discussed federal and possible state benefits payable to the family of a firefighter or EMS provider who died in the line of duty, the end goal for every emergency service worker is to have a good, long, and fruitful career, after which he or she can enjoy a well-earned retirement. Being a civil servant is not commonly the first variable in an equation for building tremendous wealth. Depending on where in the country you live, salaries for firefighters and EMS providers can vary significantly. Volunteers routinely make little to nothing and may have nothing to show upon their retirement from such an agency after decades of service. Full-time personnel who also receive benefits may have access to a pension or a deferred compensation plan. While it is becoming increasingly uncommon, some may even enjoy a continuation of health insurance benefits into retirement. Regardless of what a firefighter or EMS provider earns, he or she must keep principles of retirement financial planning and management in mind. Ultimately, it is never too early or too late to begin saving for retirement. Beyond typical retirement plans, the Internal Revenue Service also recognizes other types of financial plans that provide tax benefits for paying medical expenses or college education. All facets of retirement and financial planning should be considered when developing a roadmap for financial stability. Essentially, firefighters and EMS providers have difficult jobs with increased risk of injury or death. While it may not be pleasant to think about, no one lives forever, and end-of-life planning is important to help ensure dependents and family members have the financial means to support themselves in the event of a debilitating injury or even death. One of the most common retirement vehicles for public employees is a pension system maintained by either the state or an individual governmental entity. These systems vary from state to state. Some require joint contributions from the employee and the employer, whereas others require only the employer to make contributions. Regardless of how the system is run, it is not uncommon for the systems to require the employee to contribute into the system for a set number of years to be vested in the system, meaning the employee is eligible for retirement benefits once he or she meets other eligibility requirements. Pension plans come in two flavors, if you will. The first is a defined benefit plan, where an employee is entitled to a specific monetary benefit at a specific age based upon variables such as years of service, age at retirement, and average salary over time. These defined benefit plans do just that. Based upon a calculation, the benefit received by the retiree is fixed or defined and rarely changes, with exceptions based upon scheduled return on investment or cost of living increases. In contrast, defined contribution plans do not guarantee a specific benefit upon retirement. Rather, the benefit amount is dependent on the amount of funds invested over time and how well the investments perform. The more money in the account, the greater the periodic payment in retirement. Such a plan is similar or akin to a deferred compensation plan as available to private employers, such as 401k plans. The IRS also has numerous non-pension-based retirement plans that can be used for the accumulation of funds to support an individual's retirement. In the private sector, such deferred compensation plans are referred to as 401ks based upon the IRS code that governs them. Public education employees have a 403b option, while other state and local government employees have access to 457b plans. Deferred compensation plans are governed by ERISA and allow employees to invest pre-tax dollars in an approved retirement account where the investment hopefully grows over time. The employee then pays tax on the money as regular income when it is withdrawn upon retirement. Some employers try to encourage participation in such deferred compensation plans by matching employee contributions into their plans. Such matches may not be dollar for dollar, and they may also be capped up to a certain amount depending on the employer. Regardless, taking advantage of employer matching is a great way to increase the value of any deferred compensation plan if available. Again, the IRS has many different types of financial vehicles that can be used to help people save for retirement, such as IRAs, Roth IRAs, SEPs, and other deferred compensation plans. The rules that define who can participate in these accounts, how much can be contributed, at what age a person can withdraw funds without a penalty, and so on, can be complicated and vary based upon the type of account. The information provided here and within the textbook is designed to help raise your awareness of the need to plan for retirement. It is by no means a comprehensive dive into how these various retirement vehicles work, nor is it designed to provide you with any advice on how to prepare for your own retirement. Anyone interested in learning more about this topic is encouraged to speak with a financial expert. As far as protective service agencies are concerned, many states, larger municipalities, and private employers run their own pension systems. Again, IRS regulations define how such systems are maintained and operated. Another nice benefit available to many employees are cafeteria plans that allow employees to move pre-tax dollars into a special account to use that money for health-related care, medical expenses, dependent care expenses, group term life insurance coverage, and other similar programs. A popular option under such plans is a flexible spending account that reimburses employees from pre-tax funds for allowable expenses such as dependent care assistance, adoption assistance, or medical care expenses. Flexible spending accounts and cafeteria plans function under specific IRS rules, so they may not provide a significant benefit for everyone. Not all employers provide such plans either. For those who use them, however, these plans can help reduce the employee's tax liability at the end of the year. Another great option for those who want to pay for formal education are educational savings or 529 plans. Such plans allow individuals to invest money and realize the growth on those investments tax-free so long as the money is used to pay for qualified education expenses such as tuition, books, room, board, and other associated fees. Another end-of-life consideration for anyone, firefighters and EMS providers included, is a need to determine how assets are distributed between your survivors. Each state has laws that allow people to create wills and trusts, which are legal tools for transferring assets and property to others, commonly upon death, although in the case of a trust, no one needs to die for the property to be transferred. A will is a legal document that simply tells the probate court who should receive what property upon an individual's death. While having a will in place does not avoid the probate process upon death, it does help alleviate confusion and potential fighting over a decedent's assets by his or her survivors. Trusts, by comparison, are a mechanism by which property and assets can be passed automatically upon death without going through probate. Again, trusts have uses beyond the passing of property upon death, and even the living can benefit from a trust depending upon the circumstances. As just mentioned at the start of this slide, wills and trusts are governed by state law. Depending upon the amount of assets and circumstances involved, estate planning can be very complicated. Besides the desire to avoid probate while also ensuring property and assets pass to the right person, having properly planned for the transfer of property upon death through the use of wills and trusts can help avoid or reduce tax liabilities for the estate. If you are thinking about end-of-life estate planning, it is strongly recommended that you contact an attorney in your area who is familiar with such end-of-life planning. Some state bar associations may even provide free seminars or will creation for members of the protective services community. Insurance plans are another way to help ensure the financial stability of loved ones in the event of some type of catastrophic outcome for the insured. One popular type of insurance is life insurance, which pays out a death benefit to beneficiaries upon the death of the named party. There is both whole life as well as term life insurance. Which type is right for the insured and his or her family depends upon personal circumstances and individual needs. There are also insurance options for accidents, short-term disability, long-term disability, and catastrophic health issues. These various insurance plans are different from workers' compensation or on-duty disability plans, as they provide protection even when the injury or illness occurs outside the workplace. In some cases, employers may even provide group insurance plans at no cost or at a discounted premium to employees. Regardless of what may or may not be available through an employer, individuals are always able to obtain insurance coverage privately outside of the employment relationship if desired. The laws governing such insurance policies are often defined at the state level. Again, when exploring the different types of insurance that are available and whether or not such coverage makes sense for you and your family, it is recommended that you consult with someone familiar with the different types of insurance products available, as well as the benefits and drawbacks associated with each. This information was provided once again to just raise awareness for those within the protective services professions. Lastly, we already discussed end-of-life decisions and advance directives as they relate to EMS patients in a previous presentation. Those in fire and EMS should recognize the value of those advance directives, and it is not a bad idea for firefighters and EMS providers to have their own living wills or powers of attorney for healthcare just in case they find themselves in the same position as some of their former patients. Many states make these documents freely available so they can be prepared without the assistance of an attorney, although legal guidance in such matters is often well worth the price paid for those services. To conclude, we covered a lot of laws in this chapter that relate to employee safety, health, and benefits. We talked about the Occupational Safety and Health Act, which was written to ensure safe and healthy working conditions for the nation's workforce. This led to the creation of the Occupational Safety and Health Administration, which promulgated regulations related to occupational safety and health. These standards deal predominantly with construction work, agriculture, maritime operations, and general industry. The General Duty Clause, however, helps to ensure industry-wide standards are used to further define safety and health requirements in unique professions. While OSHA does not apply directly to public employers, many states have adopted various OSHA regulations as law or have actually become OSHA-approved planned states, whereby the state enforces OSHA regulations against public employers. OSHA defines different types of potential violations under the law, and the EPA extends OSHA hazardous waste operations and emergency response requirements to state and local government employers. We looked at some of the provisions within the Patient Protection and Affordable Care Act, along with the provisions of the Fair Labor Standards Act as they relate to minimum wages, hours worked, overtime, child labor, record keeping, and the 7K Firefighters Exemption. The provisions of the Family Medical Leave Act were explored, as were some of the common provisions within various state workers' compensation laws. Lastly, we looked at retirement and end-of-life planning by discussing the Employee Retirement Income Security Act of 1974, the Federal Public Safety Officers Benefit, and other financial planning and management topics such as wills and trusts, personal insurance lines, deferred compensation and pension plans, educational savings plans, flexible spending plans, and advance directives. As far as employee safety, health, and other benefits are concerned, there are numerous laws at both the state and federal levels that are designed to look out for the well-being of our emergency responders. Given the width and breadth of these numerous laws, the cursory examination provided within this presentation and the textbook merely scratches the surface of what laws exist and how they apply to benefit firefighters, EMS providers, and their families. If you found any of these topics interesting or wanted to learn more about them, I would recommend that you explore the subjects further through your own research or by contacting an attorney, human resources professional, or financial planner with expertise in the respective subject. With only a few chapters left in the textbook, our next presentation will delve into the laws that govern the employee-employer relationship.